Good evening, ladies and gentlemen. We are extremely delighted that all of you have readily come here to attend this program, which we hold very close to our heart. It has been a continuing session for many years, and we hope to keep this alive. Today, we are honored by the presence of former Judge, High Court of Kerala, Advocate Nagaresh, and we also have our dear head of the department as well as our members with us. We are delighted that we also have interns and juniors. Most of you are the intended audience for today. So without further ado, we would beg to go forward with the program. And to begin with, I request Aditya Tejas to render the welcome address, and welcome all of you.
Good evening. Honorable Chief Guest for the day, Justice Nagaresh, retired Judge, High Court of Kerala, Senior Advocate. The Honorable Judicial Members, Justice Sunil Thomas, retired Judge, High Court of Kerala, Justice Haripal, retired Judge, High Court of Kerala, and the Honorable Administrative Members, Rajmohan Agarwal sir, and I know the absence of Rema Madam also. Senior members of the bar, friends, colleagues, and all of you joining us today. It gives me immense pleasure to welcome all of you to the continuing legal education program organized by the Central Administrative Tribunal Advocates Association. The continuing legal education program was conceived with the object of fostering a deeper engagement with legal principles and strengthening professional competence within the bar. Several years ago, the association initiated a series of such lectures and academic sessions which were led by some of the most prominent minds in service law. Many of them are present amongst us today. Each of those sessions offered us an opportunity for professional growth, and all of these remain fondly in our memories. Today's program, it marks the resumption of that initiative after a period of small dormancy. The impetus for the revival came from the sustained interest and enthusiasm shown by the junior members of our fraternity who expressed a genuine desire to engage more deeply in the discipline of service law. As Tanuja ma'am had just invited all of you, you are the targeted audience. It is for you that these sessions are being conducted. But one thing that we realized as we prepared for these continuing legal education programs is that this is not solely for the new entrants into the profession. For those entering the profession, it offers an introduction to the intricate and intellectually rewarding field. For the junior lawyers, it gives us an opportunity to develop a deeper understanding of the finer nuances of law and of service law. And as far as the senior members are concerned, it gives them a forum for reflection, discussion, and also to update themselves of the latest developments in law. This is the very objective of the continuing legal education program: to nurture legal scholarship, encourage intellectual curiosity, and equip practitioners to contribute meaningfully to the advancement of law. Now, to revive this venture of ours, we could think of no one more suitable than our very own Nagaresh sir, former Judge, High Court of Kerala, who was also a member of the Central Administrative Tribunal Advocates Association, and fortunately, he was also the secretary during a small tenure, 95-96 tenure. Now, Nagaresh sir, prior to his elevation to the bench, he has served with distinction as the Deputy Solicitor General of India and has built an exceptional practice that spanned representation on behalf of applicants, several institutions, labor unions, and even the Union of India as the Deputy Solicitor General of India. Having commenced his professional journey under the guidance of Senior Advocate O.V. Radhakrishnan sir, he developed a strong foundation in service jurisprudence that would later become one of the defining traits of his profession. His varied professional experience enriched his understanding of the law and contributed to a career marked by distinction, versatility, and excellence. As a judge of the High Court, he earned widespread respect for his clarity of thought, practical approach, and his unwavering commitment to the cause of the little man. His judgments reflected not only sound legal reasoning, but also a deep appreciation of the realities faced by ordinary citizens. It is therefore a matter of great honor and privilege to have him amongst us this evening. I welcome you, sir, to this function. I would also like to warmly welcome our HOD and judicial member, Justice Sunil Thomas, retired Judge, High Court of Kerala, to this function. I also welcome Justice Haripal, retired Judge, High Court of Kerala, to this function. I also extend a heartfelt welcome to our administrative members, Sir Brajmohan Agarwal, sir. Our judicial and administrative members need no introduction, for they are the very foundation of the institution and they have continued to inspire us. In fact, they are the motivation behind this very continuing legal education program as well, and their continued support for this initiative and for our continued success. Now, I also extend a warm welcome to all the senior members of the fraternity, as well as our other legal and non-legal members joining us today. We commenced this series with a very small and very simple topic, Introduction to Service Law. Now, this was intentionally worded in the most liberal format so that it can be inclusive for even the newest entrants into the profession. It is meant to be a very engaging session. It is meant to just draw you into the profession, draw you into service law, and give you an understanding of what exactly entails, what exactly happens in service law. This education program, we hope to bring before you some of the most experienced and accomplished practitioners and scholars in the field, and their insights and experience, we hope, will deepen our collective understanding of service jurisprudence and contribute to a richer appreciation of its scope and significance. With these words, I once again gathering, and I hope that all of you have a very engaging session. Thank you.
Thank you, Aditya. I now invite Honorable Justice Sunil Thomas, judicial member and HOD of Ernakulam Bench, to give an introductory address. Welcome, sir.
My esteemed brother, Justice Nagaresh, Brother Justice Haripal, Brother Agarwal, senior lawyers, my dear young lawyers. So today we are going for the launching of the continued legal education program. In fact, Mr. Hariraj, when he was the president of the association, tried it very successfully. It continued for 6-7 sessions, it seems. It was yes, more around 10. And it was wonderfully well done, well arranged and well attended. So we are going for the second module of that, and we will commence it today with the brother just Nagaresh doing the first inaugural session. See, it's a continuing legal education, not confined to young lawyers. Continuing legal education or learning is a continuing, unending process. Not only that you learn, you teachers, we sitting over there also learn every day the nuances of the service law, which is rather, everybody says that it's a very dry subject. Definitely it's a very hard subject, very, I may say to a certain extent it is a dry subject, but how to make it attractive, how to make it to catch your attention, this is the challenge. I'm sure that this Nagaresh will be able to do it well, and I congratulate the organizers for taking the initiative. Let it go successfully. What I understand is that every month we are going to have one class to be taken. We will have render whatever assistance that we can have, we will give that. So let it be a very, very successful program. I formally invite Brother Nagaresh to have the inaugural address and go for the first session. So thank you so much.
Thank you, sir, for the introductory address. I now formally welcome former Judge High Court of Kerala, Nagaresh sir. Nagaresh sir is very much a part of our fraternity, and we are delighted that he was readily available to take the session. So I welcome you, sir.
It is quite discomforting that when so many lawyers are standing on the backside and we have to make them stand for the entire length of this But I will try to finish it within 20-30 minutes. Honorable HOD Justice Sunil Thomas, Justice Haripal, Justice Justice Haripal, Justice Brij Bhushan, Srimati Advocate Rekha Vasudevan, Advocate Aditya, M.N. Manmadan, our central government, heading the central government panel, Sheila Devi, the Bar Council elect member. I will say the doyen of this tribunal, Mr. M.R. Rajendran Nair, and his equally eminent son, Hariraj, equally or more, Hariraj, and my dear friends. I am in fact very happy. I don't know how many of you are actually practicing here, but I am very happy to be here today because Central Administrative Tribunal was the training college for me as a lawyer. I got enrolled in 89 December and started practice in 90. That was within 2 years of starting of this. At that time, my senior friend Mr. M.R. Rajendran Nair and my senior O.V. Radhakrishnan, and from railways one Shivan Pillai, Mr. Advocate late Shivan Pillai, who is the senior of Mr. Govind Swami, were the kings in this court. Even today it continues like that, I think. So this was my training college. Later when I started independent practice, this became my breadwinner. Most of my cases were in the Central Administrative Tribunal. Then in the year 2014 or so, I became Assistant Solicitor General of the Kerala High Court. Now it is called Deputy Solicitor General. And from there, I was elevated. So thereafter, I couldn't come back. So this is a sort of comeback and return to the Ghar Wapasi. That is how we call it. See, I am not an orator. When I practiced in the Central Administrative Tribunal, very many eminent lawyers were there. Nagaresh was considered as a good average lawyer, but not a lawyer with academic bent. Even when I became a judge of the High Court, I had so many followers among the lawyers because I used to give some orders and all. But there was no allegation that he is academically brilliant. Never. So I wondered why when a new learning class, continuing legal education class, why I don't know why the association, CAT Advocate Association, found me fit to take this class. So when I was told that this is the first class of in the service, the classes here will be mostly service law oriented, I thought instead of giving you a lecture on the usual subjects of service law, Uma Devi, Haryana versus state of Haryana versus Pyara Singh, like that, I would start from the very beginning. And what I am going to present before you will not find, I am sure, in any of the textbooks available in this library of the Central Administrative Tribunal, because I am going to speak to you about service law which existed in India even prior to the advent of East India Company. I have heard so many lectures on service law, and everybody will start saying that service law commenced from the period of East India Company, then the Government of India Act, then the Constitution of India, then so many service law regulations. I am going to speak to you about service law which existed prior to the East India Company. Service law encompasses rules and regulations governing the recruitment and conditions of service of employees. In the present day, we have confined our definition to the government employees or public sector employees alone. But basically, the law is the same. The general law is the same. What was the position in India of workers or employees prior to East India Company, or in ancient Indian legal history? What is the position of service law? That is what I propose to tell you. I will try to finish it within 20-30 minutes. You must understand that the concept of master-servant relationship, which is the fundamental basic of service law, modern service law, that concept of master-servant relationship did not in fact existed in India till industrialization or Britishers came. In India, all workers or so-called workers or employees were expert professionals, except domestic workers or workers of the king or soldiers. All other employees were almost professional, independent professionals, and there was no employer-employee relationship. I will tell you an example. If you want to construct a house, if a Raja or a landlord want to construct a house and calls the mason and says, I want to construct a 2-storied palatial bungalow in this place, please do it for me. He will not come and start construction at the desire as liked by the landlord. He will come, he will examine the land, he will examine the strength of the soil, he will look in all other technical aspects, he will look into Vastu Shastra, and he will come and he will put a stick on the earth and say, house has to be constructed here. If the landlord say that no, I want house to be constructed there, he will say, no, I will not, because this is the most appropriate place for construction. If you construct house at that place, that has some disadvantages, maybe soil strength, everything, but and his advice or his suggestions was accepted. If it is not accepted, he will not construct the house. They were such experts that people accepted their expertise and constructed house at their desire, at their advice. That is why many of the ancient buildings are like temples of Kathmandu or Amarnath. Many earthquakes came, many things came, those buildings are still there without intact, old buildings. That shows their expertise. They were respected, they were not treated as master and servant. They were masters in their own field. This was so in respect of all other fields also, whether it is a blacksmith, carpenter, they had their own expertise, and it was a contract appointment, like rather coming near to contract appointment rather than your master and servant relationship. That was the system prevailed in India. Nevertheless, there were domestic workers and certain other categories who had no such expertise, and we can say that there is a master and servant relationship like situation. Such workers were there, and there were some labor laws, I will say regulations, governing various factors, rules and regulations which is available in ancient Indian texts like Shukra Niti or Manusmriti and such other old Indian texts. For example, I find that there were various branches of law. Service law existed even at the time of Manu, that is 1250 before Christ. Consider, it is before Christ, 1250 years ago. India had developed rules for various branches of service law. Payment of wages were described in Sanskrit as Vetana Dana. This is the term. Vetana Dana means payment of wages, and there were rules regarding that. Swami Pala Vivada. Swami is the master, Pala is the servant, Vivada is the dispute. Swami Pala Vivada means master-servant dispute or employer-employee dispute. There were special regulations for that. Abhipetya Susrusha, which is breach of employment contracts. If there are breaches of employment contracts, how those have to be remedied or compensated was a legal subject in ancient India. Then there was a Vedana Snapa Karma, that is non-payment of wages, remedy for non-payment of wages. Mind you, these rules were there 1250 years ago, before Christ, not ago, before Christ. Then rates, classification of rates of wages. Wages were classified in Shukra Niti as Karyamana, Kalamana and Karyakalamana. Karyamana means work rate wages. Work rate wages. Kalamana means time rate wages. Karyakalamana means work come time rate wages. The today's system, today with the system followed by, we have time rate wages and other wages also. This system existed in India 1250 years ago, and you will find this in Shukra Niti. You must keep in mind that in India, the first legislation on payment of wages to workers was mooted only in the year 1929 in the modern India. Then employees were categorized. There were categorization of employees. Now we say management cadre, middle management cadre, workman's cadre. Such categorization was there. And in the Shukra Niti, there is a verse which says, Mando Madhyastha Shighra Trivide Bhritya. It's a long verse. I am not troubling you with the Sanskrit word. I will tell you the meaning of it. The employees are graded into three. Mando. Mando എന്ന് പറഞ്ഞാൽ നമ്മൾ മന്ദബുദ്ധി എന്ന് പറയുന്നത് തന്നെയാണ്. ബൗദ്ധികമായിട്ട് കുറച്ച് കുറഞ്ഞവര്, അൺഇന്റലിജന്റ്, അതാണ് മന്ദോ, ഡൾ ടൈപ്പ്. മധ്യ, the middle type, and Shrestha, the sharp type. Employees were categorized on the basis of their merit, not on the basis of caste, religion, seniority or anything. Employees were categorized and paid wages purely on merits. Whether it's right or not is something different. What I am telling is 1200 years before Christ, India had a system of categorizing employees. Their wages were determined on the basis of their capacity or merit. Then we have a Minimum Wages Act which came into year 1948 or so. Minimum wages were prescribed in Manusmriti. The Manusmriti, this is a Sanskrit sloka beginning with the words Panodeyo Avakrishtasya. I am not reading the Sanskrit sloka. I don't want to trouble you and trouble me also. I am also not very familiar with the Sanskrit. It says, one pana must be given daily as wage to the lowest. One pana, oru panam, has to be given, minimum to the lowest category employees. 6 to the highest. Likewise, clothing every 6 months has to be provided, and 1 drona of grain every month. So the wages is minimum 1 pana every day. The difference between the ratio between the low paid employee and high paid employee is 1:6, and employees will have to be given dress every 6 months, clothing every 6 months, and 1 drona of grains, oru para nell dhanyam, every month. This was the minimum wages prescribed in Manusmriti. Apart from prescribing minimum wages, Manu laid down the ratio of lowest and highest wages. This was written in 1250 BC again. Mind you, there were provision for compensation for breach of service contract. 1000 years before Christ, in India, there was provision for compensation of breach of service contract. The Narada Smriti. Narada Smriti provided for payment of compensation in two types of instances. One, when master was ready to receive work and the servant was not ready to deliver work. If master was ready but the servant is not ready, servant had to compensate the master. And when the servant was ready to work but the master was not ready to accept or receive work, master has to pay. Look at the position. When I see the scene of today's Kerala workers in many places, like Kerala headload workers. Tell you an example. If any one of you is doing any business, you know. If you want to do headload work, you have to approach them. You can only engage them. It is their statutory right. Many employers go to their shed and ask them, please come. The lorry is waiting. Unless you come and unload it, I will have to pay demurrage to the lorry owner. They will say, wait, we are taking tea. 1 hour tour. I sat in the police protection bench in High Court. There were many cases where complaint of the employer is that these workers are not coming. Please allow us to engage our own workers. This practice is there still in Kerala in many places. And all of you must know. But here in Narada Smriti, it is stated that if an employee is refusing to work, he has to compensate the employer. And enhancement and reduction of wages. Yajnavalkya laid down rules as to when an employee should be paid wages more than the normal, as also when the employee is entitled to receive less wages. An employer is entitled to pay less than the agreed wages if the employee violates the time and place of work and thereby causes loss to the employer. Yajnavalkya Smriti. At the same time, it was mandated that if an employee is unable to do work entrusted to him owing to illness, he may complete the work through another substitute worker. He may complete the work through another or after recovering from illness. He can get it done through another substitute or after recovering from the illness. This was the rules then prevailed. In such cases, the employee is entitled to get full wages in spite of the delay in completing the work. According to Yajnavalkya, if the employee puts forth special efforts and brings more profit, the employer must pay more than the fixed wages. This was the wage structure prevailing. Our Payment of Wages Act 1936 in section 10 provides for deduction of wages for loss caused by an employee, but the act does not provide for or contemplate payment of extra wages for better work or more work. Now, bonus is always an issue in Kerala and all over India. The bonus was prescribed 1000 years before Christ in India. The system of payment of higher wages to an employee for rendering special efforts, which brings in more profit that existed in ancient India, was distinct and apart from payment of annual bonus. Payment of bonus is mandated by Shukra Niti. It says, every employee should be granted 1/8 of his salary as bonus annually. That is 12.5%. 12.5% bonus is to be granted. Our statutory mandate today is only 8.33. 8.33, mind you. This was the provision for bonus as existed then. If an employee does his work efficiently, he should be granted an extra remuneration equal to 1/8 of the wages. Ordinary employee 1/8. If an employee is extraordinary, he should be given another 1/8. This was the position. Now, what about premature termination? If an employee is prematurely terminated, what is the position today? First, we will have to see whether he has worked for 240 days minimum continuous service. If you want gratuity, till recently it was 5 years. Now gratuity minimum period is reduced. 1 year akile. Eh? 1 year. What was the provision? The Dharma Kosha mandated that an employer dismissing an employee prematurely should pay wages as well as fine. If an employer dismisses a workman prematurely, he shall pay him extra wages and pay a fine of 100 panas, unless the workman is at fault. The rule does not require a minimum service period of workman for receiving the benefits, whereas section 25F you have to complete 1 year. This was the position of termination of service, compensation for termination of service. The ancient Indian labor laws provide for leave also, mind you, leave entitlement. The Shukraniti says, for every employed person, there must be sufficient provision for leisure during the night and also for holidays with full pay, unless the nature of the job is emergent. Holidays with full pay should be given on the annual ceremony, Shraddha, and other religious functions. If you are, it is a Shraddha day, your father and mother is, it is their annual remembrance day, like Shivara, Aluva, Manapuram. Leave should be given with full wages. That's what the ancient Indian law said. Shukraniti provided for sick leave in a liberal manner. It said, no deduction should be made from the wages if an employee is sick up to 1 week. Up to 1 week, if you are sick, no deduction. You have to pay the entire salary. An employee suffering from long illness can send his nominee to work in his place. If employee is ill for longer days, you can send a substitute. Substitute can work. A highly qualified employee should be paid half the wages for the entire period of illness. Highly paid employees. There were provisions for provident fund also. The Shukraniti again said, 1/6 or 1/4 part of the wages of an employee should be deducted, and the said amount should be paid to him either in full or half after 2 or 3 years according to his requirement. So your provident fund amount contribution is deducted and it is paid to him after 2 or 3 years, not on the whims and fancies of the employer, according to his requirement. Such provisions were there. The latest development in the modern service law can be said to be dying in harness scheme. Dying in harness was not a legal right earlier. Even now it is not considered as a legal right. But in ancient India, dying in harness was a legal right. The Shukraniti provided for unconditional appointment of legal heirs on the death of an employee. Unconditional. If an employee is dead, unconditionally, if there is a legal heir who is willing to work, he should be work. If an employee dies before retirement, his son becomes automatically entitled to get an employment of the father. After attaining majority, his wages should be determined according to his qualification. There were provisions for pension, family pension, wage register, and even for promotion. Promotion rules were there. The promotion rules said, as and when an employee gets experience, he should be promoted as per seniority, and in the end he should be given important position of headship. Talaivan, headship. As and when he gets this thing. So what I am, in short, whatever provisions, whatever branches of labor law which we are dealing with today were in existence in India before the British era or East India Company era, maybe much before that, even before Mughal. So India is a country which is rich with labor legislation stuff. For some period, these laws were not followed. Then East India Company came. They thereafter initiated or they legislated, made rules for their own employees. Those thereafter British government came. Even when British government came, the rules were made for their own employees to control the bureaucrats and not for the public. Then in 1935, the Government of India Act came. When the Government of India Act came, Public Service Commission was constituted for the first time for federal and provincial government. Separate public service commissions were constituted in 1935. Thereafter, it is the Constitution of India after getting independence. I need not tell you what are the provisions. Article 14, 16, and Article 309, 10, 11, up to 328, I think. Article 328 governs the regulation of employment of union and state legislatures. Friends, I do not want to push more. As a this learning class, I think you should know before venturing into the latest law, modern law, you should keep in mind that our country is a country which had rich labor law or service law legislations or rules. We are not new to it. With this submission or this with which I conclude, I think from the next session onwards, Rekha can proceed with the modern Indian legislature. Thank you.
Thank you, sir, for that very insightful session, especially the interesting notes on how rich our culture and heritage has been and what we have actually drawn upon when we brought about the present existent system. Now, to conclude, I invite Advocate Kailesh for the concluding remarks.
I'm keeping it very short because of the time. Good evening to all. After a long gap, we have come back with the continuing legal education program decided and organized by the Executive Committee of the Central Administrative Tribunal Advocates Association. It is my privilege to offer the vote of thanks on behalf of our association. I express our heartfelt thanks to our Chief Guest, Honorable Justice Nagaresh sir, for delivering such an enlightening and enriching session. His Lordship, we are truly grateful for your time and valuable insights. I express our sincere gratitude to the Honorable members of the Central Administrative Tribunal, Justice Sunil Thomas sir, Justice K. Haribal sir, Administrative Member Brajmohan Agarwal sir. I thank your Lordships for your gracing this occasion with your esteemed presence. I would also like to acknowledge with gratitude the support extended by the Registrar and the entire staff of the CAT. Their cooperation contributes immensely to conducting this program. I also sincerely thank our President, Rekha Madam, and all other committee members for organizing and making all the necessary arrangements for seamlessly conducting this program. I thank the respected senior advocates, all the members of the association, and everyone present here for making this event memorable. Once again, I also like to express our sincere gratitude to the chief guest, honorable members, senior advocates, members of the association, staff of CAT, and all the participants for taking time out of their busy schedules to be with us this evening. Your presence and participation have greatly contributed to the success of this program, and we are truly grateful for your support. With these words, I thank everyone and wish you all a wonderful evening. Thank you.
Thank you, Kailesh. Before we conclude, we have a small token of appreciation for you, sir, and I invite Advocate Rekha Vasudevan, our beloved president of this committee, to hand it over to you. Thank you very much. Thank you, sir, for being here and those very wise words. Thank you all for being here. We are about 80 or so and we are extremely glad that you have accepted our invitation and come. Thank you once again. We hope to have classes continuously, and we hope your support will also endure. Thank you.